Hi, everyone. This is Adam Cohen. I'm an immigration attorney with Siskind Susser in Memphis, Tennessee. And I've been trying to give some updates from time to time about the area where I focus my practice, which is largely in academic and healthcare immigration. And, I was thinking I would do this sort of on a sporadic basis, but it turns out that there has been guidance, rapid fire guidance, pretty much every week since I started doing this. And this week is really no exception. It has to do with SEVP's recent guidance that is reversing allowances that they had made to students in universities in terms of distance education. They're basically completely pulling the rug out and reversing course on that and really restricting greatly the distance learning allowances for students in universities. So I want to go into that. I also want to refer you all to the past Facebook Live event on this updates that we did day of. Greg Siskind and I did day of. You can find it on Facebook Live. And it's really just Greg and I just kind of looking through the guidance, asking each other questions, really just trying to think through possibilities. And there's even been updates since that time. So we're going to talk about that as well. So let's just kind of start with a little bit of some of these acronyms because these terms can be confusing, right? So Department of Homeland Security has a component to it called Immigration and Customs Enforcement, right? Which everyone knows as ICE, the component that is involved in raids and prosecuting removals and deportations and things of that sort. But ICE also has a subcomponent under it called the Student and Exchange Visitor Program, which is responsible for monitoring compliance of F1 students, M1 vocational students, and J1 exchange visitors. So there is a basic rule for SEVP for F1 students and M1 students that they need to maintain a normal course of study, right? So that they're maintaining their student status. And part of that is this distance learning regulation. Okay, so there's a regulation for F1s that basically state that no more than the equivalent of one class or 3 credits per semester may be counted toward the full course of study requirement if the class is taken online or through distance education. Okay, and this is kind of important when it's talking about online and distance education. It's talking about those classes that do not require the student's physical attendance for classes, examinations, or other purposes integral to completion of the class. Okay, so that kind of becomes useful later as we talk about how the policy has changed and then changed again with this kind of reversal of course. The other thing I'll note to you all is that for language study programs, no online or distance education classes may be considered to count toward a student's full course of study requirement. And the same is true actually for M1 students. They have a separate regulation that says that they're not allowed to do that. It can't count toward their full course of study, that they do distance learning classes, okay? So let's just talk a little bit about what happened when the pandemic hit in the US and there was a national declaration of emergency. That happened on March 13th. And because of that, SEVP responded really the same day that they would, basically for the duration of the emergency, which is very important, he said that this adaptation would be in effect for the duration of the emergency, that they would make certain or allow certain procedural adaptations. So schools would just generally, they would allow schools to provide adaptations related to distance learning, et cetera, and allow more distance learning classes to count toward a full course of study, just understanding that the universities need to make these determinations to protect the safety of students and of faculty as well. And there didn't need to be a bunch of different new I-20s reflecting this. The I-20 is the document that F1 and M1 and J1 individuals have that shows how they're complying with maintenance of their status. Okay, so no new I-20s needed to be released here. It was just going to be procedural adaptations provided to SEVP. just understanding that, you know, this was an emergency situation. Okay. Basically, they said that SEVP said they would continue to monitor the situation. They could adjust the guidance, you know, as needed, which is another important component as well. Okay, so they had not released any guidance in the fall. They actually had released a very significant FAQ, maybe 23-page FAQ over time. It just kind of evolved, and new questions were added and new clarifications. They permitted English language students, just kind of as part of the F1 category in general. They seem to be allowing for online classes for language students and for M1 students as well. And as I mentioned, you know, a lot of flexibility for general F1 students in terms of distance learning and distance education. They had not released any guidance related to what they were going to do in the fall. And we have been waiting for a long time. Universities and students have been waiting to see what the fall was going to look like for SEVP. Okay. So now let's talk a little bit about the new policy. And just going to kind of go through this in general. Again, if you all want a lot more of the details, you can go to the Facebook Live event that Greg Siskind and I had done. But basically what they're kind of providing for three models here and what they're going to allow. So the first thing is that students attending schools operating entirely online may not take a full online course load, okay, and remain in the United States. So no full online course load. The U.S. Department of State will not issue visas to students enrolled in schools or programs that are fully online for the fall semester, nor will U.S. Customs and Border Protection permit those students to enter the United States. And I just want to note very quickly that the Foreign Affairs Manual, which is the manual used by consular officers at embassies around the world, they have already instituted some guidance in the Foreign Affairs Manual, which I'll try to get to as well with respect to this policy. Active students currently in the United States enrolled in such programs must depart the country or take other measures, such as transferring to a school with in-person instruction in order to maintain their lawful status. Or they could face immigration consequences, including initiation of removal proceedings, right, related to not maintaining their status in the United States. Okay, so that is the full online. That's really the big crushing part of this because it's removing the trust that they had formerly placed in the universities to assess the facts on the ground. What are the COVID numbers? You know, what is the science telling them? What are the risks in those institutions, you know, with the dimensions of the classrooms and the housing situation there? What is the larger, you know, situation in the city? You know, what declarations of emergency are in place and what phase are these cities in their, you know, reopening? So there's a lot of things that, you know, should have been left to the discretion of institutions to make. And instead they're basically putting the universities in these strictures that are completely unnecessary, and we'll talk about that too. So students, that's the first model, entirely online. Then what about students attending schools operating under normal in-person classes? They are bound by the existing federal regulations, which I had already mentioned originally, about the, you know, one online class can count toward the full course of study. Now this one's an interesting one. Students attending schools adopting a hybrid model, that is a mixture of online and in-person classes, will be allowed to take more than one class or 3 credit hours online. Okay, so this is the hybrid model. Is, you know, it doesn't really say, but, you know, there is some amount of in-person classes, okay, that are part of this. And if there is a hybrid model in place, then the regulations don't necessarily apply here. More than one class or 3 credit hours online is acceptable. However, the individual student's course load cannot be fully online. Okay, so that's very important. And the schools have to certify to SEVP through Form I-20 that, you know, for each, and that's a document that's for each student, each international, you know, F1 or M1 student or J1 student, they have to certify in the remarks section of the I-20 that the program is not entirely online, that the student is not taking an entirely online course load for the fall 2020 semester, and that the student is taking the minimum number of online classes required to make normal progress in their degree program, right? So a student could presumably take maybe just, maybe just have actually one in-person class and still qualify, if in this situation, as long as, the school feels comfortable certifying that the minimum, that the student is taking the minimum number of online classes required to make normal progress. Another thing I'll just point out is, remember that an online class to them, according to the regulations, does not require a physical attendance component, so a component that's related to examinations or things of that sort. So that could factor in here as well, as a possible strategy, that the student is taking mostly online classes, but has one, in-person, so to speak, class, because it does have a physical component to it. So that's something that's interesting. It's definitely worthy for, universities and for students to kind of explore, students to explore with their international students and scholars or international office. Now, they do say in this guidance, the above exemptions do not apply to F1 students in English language training programs or M1 students who are not permitted to enroll in any online courses. So allowances that they made for English language training programs or M1 students have also actually, it looks like they've been erased wholeheartedly under this memo. They're not even allowing for the possibility of a hybrid model. So those are some of the strictures. Now, they say for the fall 2020 semester, the continuing F&M students who are already in the US, they can maintain, they may remain an active student if they make normal or active status in SEVPS, if they make normal progress in a program of study or are engaged in an improved practical training program. If the problem is if the school changes its stance mid-semester, so maybe they had a hybrid model and now because of the safety of the students and the faculty, they switch to an only online model. What is that going to mean? That could be that could cause students to, lose their status, international students to lose their status and have to leave the US. Because the school was trying to make choices to protect students and faculty and ended up, with this, this incredible pain to F1 students. So it's really a rock and a hard place for universities in a lot of ways. For those students where it's a fully online model, they can remain active in SEVPS, but they have to leave the US. So that prompts a lot of other issues. And we'll talk about that. But one of them is, what about OPT for those graduating seniors this fall? They would typically be applying, 90 days before the end of their course of study. And there isn't an allowance right now for filing an I-765 for work authorization from abroad. So they could lose their opportunity for OPT. There's another thing here. Let's see, I can't find it very easily, but I can say that, the individuals who have been studying from abroad in, a fully online model, and now the school is considering a hybrid model. Those students actually have to come here to the US. They can't do fully online from abroad if the school's doing hybrid. So they need to find a way to get here. And, that involves getting, a visa appointment for those who have an expired visa. It means flying here and making arrangements to come here. And maybe some of them are stuck in travel ban countries, either, pre-existing travel ban countries like Nigeria, or, I think Nigeria is only for immigrants, but, there could be some, immigrant visas, green card visas, but there could be some that would be subject under existing travel bans. And then of course, there's those who are subject to the COVID-19 bans, like Brazil, like several European nations that may have the problem getting here at this point. Now, those schools that are only going to be offering entirely online classes, they basically have to make they have to submit this operational change plan to SEVP by July 15th. They gave him only a few days. to submit this information to SEVP. I think it's like 9 days from the broadcast message from SEVP saying this is what we're going to do. It's not a lot of time. And then for those who are going to have a hybrid model, they need to make a decision and submit this information by August 1st. Think about some of these schools, like we'll talk Harvard and MIT, who have a lawsuit pending. You know, we're talking thousands of F1 international students, and DSOs have to scramble, designated school officials who issue these F1 visas. They have to scramble to issue, I shouldn't say F1 visas, they issue I-20s. They have to scramble to issue I-20s to all of these students. And so it's very, this is basically the guidance that we have right now. And, you know, it's very concerning. And the impact of it, you know, we're going to talk about several things now. That is basically the new policy. Let's talk a little bit about the impact. There are about 1 million international students in the US. And they contributed nearly $41 billion to the national economy in the 2018-2019 academic year, according to NAFSA, which is a nonprofit organization of international educational professionals that puts out a lot of this data. We talked about the difficulty that this is going to pose to universities who already have had, you know, they've basically put into plans based on the reality in their community. They have plans of what they're going to be doing in the fall. And then what about the students who have to travel abroad? And internet connections that they'll deal with. In certain cases, you know, people's homes are not safe. You know, there are plenty of Syrian F1 students here in the US as well. There are, you know, countries such as Iran that have filters that they place on internet. So what is that going to mean to students who need to access the internet, you know, for certain information? You know, what if the research topic is deemed sensitive or dangerous or hostile to the state? You know, there are so many things to think through. I'm sure I'm not even covering the half of it, of all the concerns of these kinds of policies. I talked about the Foreign Affairs Manual that came out, you know, that it's basically in qualifying for a student visa, you have to show that you do not plan to take any, let me see, that you don't plan to take any in-person classes in the United States, complete the intended course of study online from his or her residence abroad, but prefers for other reasons to be in the United States while pursuing the intended study online. There's some details here in the Foreign Affairs Manual that are definitely worth looking at. I don't want to spend too much time on that because we also want to talk about the litigation that has now ensued. Okay, so there was a lawsuit filed in the U.S. District Court for the District of Massachusetts by Harvard and by MIT. I believe there's going to be others joining, Northeastern, and I believe some institutions in California as well are looking to join on to this. And basically what they're focusing on is what I was mentioning before, which is, you know, duration of the emergency, that this SEVP guidance should be in effect, that they will adjust guidance as needed, okay? And also noting that the President's national emergency declaration has not been rescinded or terminated. So this should still be in effect because we are still in the duration of the emergency. And also Harvard and MIT, they really go into a lot of detail. I got to note, this brief, basically 24-page brief, is solid gold. It's a thing of beauty, and it was created in 2 days. So kudos to their counsel, you know, in putting this all together. They're basically talking about the plans that they carefully crafted and carefully put into place based on their own realities and the concern of the extremely contagious, you know, COVID-19 disease. So they talk about reliance issues here. Oh, actually, one other thing I don't want to forget. So SEVP guidance had also mentioned that during the height of the coronavirus disease, you know, this guidance was necessary. Okay, so they are talking about the height of the coronavirus disease, but it's actually worse now the spread of the coronavirus, now more than it was even in March. Okay, there are now over 3 million cases in the United States, and perhaps even more telling, 60,000 new cases at least 2 days ago. That was a one-day total, which is more than there was back in March. These are record-breaking in the worst way possible, record-breaking numbers of people coming down with COVID-19. And so that's, why is now the correct timing to, start requiring in-person classes? It's very, very suspicious. The ICE's action basically proceeded without any indication of having considered the health of students, faculty, university staff. They did not consider the reliance of students and universities on their pre-existing exemptions that this guidance would be in effect for the duration of the emergency. So this is very effective. There's very effective arguments in this litigation. They talk about transferring to, for students transferring to other institutions that are offering in-person classes. Who can complete a transfer in this particular time frame? The students need to be admitted to the institution. And there's a lot of paperwork that needs to go into these transfers and the releasing of SEVS records from one school to another. It's an involved process, and it's a lot that would need to be done in a very short time frame. What about those students that now need to abandon housing arrangements, breach leases, pay exorbitant airfare? There's a lot of things that are mentioned here in this litigation. And so basically what they're concluding is that this guidance is defective under the Administrative Procedures Act, which is basically to it has a preference to subject agency action to the review of Article 3 courts, the judicial branch. This is separation of powers in its essence. And basically the litigation says it's defective under the Administrative Procedures Act. It entirely fails to consider an important aspect of the problem. Okay, there's no reasoned decision-making provided. And I like how really in both of these, the litigation, Harvard and MIT here are citing to the recent DACA case, right? That allowed DACA to survive another day, deferred action for childhood arrivals, to survive another day because in rescinding this policy, the government did not consider certain aspects, of and reliance issue interests and things of that sort. So it's very fitting to see the DACA recent decision by the Supreme Court, come into play in this litigation, and is very timely as well. So they didn't consider an important aspect of the problem. Indeed, they did not consider the reasoned decision-making, any reasoned decision-making. They just said that they were carefully balancing protections implemented by federal regulations, but they did not provide any reason of why this needs to be changed at this juncture. What are the compelling reasons for that? This is a substantive rule because it is not just interpreting any guidance, it is creating and altering the students and universities' rights and obligations under the law. And therefore, there should have been a notice and comment period, a period for public commentary. And yet there was no public commentary. This just kind of came completely out of the blue and caught a lot of people off guard. So basically, Harvard and MIT are asking for a temporary restraining order and an injunction, and for this policy to be completely thrown out. As I mentioned, Stanford and USC, University of Southern California, intend to join this lawsuit, along with Northeastern University. They've all made statements to that effect. The state of Massachusetts is considering an independent lawsuit. Georgetown intends to be involved in some litigation, but it's not clear whether that would be a separate suit. And also, the state of California is actually the first state to sue the Trump administration, because I suppose that the state of Massachusetts hasn't filed anything yet, just indicating their intention. But California will be suing over this policy, and also nearly 100 members of Congress are demanding the Trump administration stop this policy. So there's congressional involvement as well. Options. Well, the options are really more options for universities in a sense, I guess, in the first part, right? In first off, considering whether they will join litigation, as many of them have. You know, a lot of their, a lot of their student body are affected here. And there are economic realities that they face by the loss of those students, and loss of diversity, and loss of many, many things. So they have a very vested interest, both as an institution and on behalf of their student body. Some of them will be thinking about joining in litigation. Some of them will be thinking, many of them have already issued statements related to the hybrid structure that they will employ to help the students. And, you know, for those students themselves, I would say in certain cases, there may be possibilities of change of status to B2, at least temporarily, to make preparations in terms of what students are going to do from here. There's the possibility for some of them who come from states where they fear for their lives, you know, for countries where they fear for their lives. And, you know, for some of them, they may be eligible for asylum protections. You know, it's very important for those students, if they don't have a good solution in terms of a hybrid structure, it's important for them to talk to a qualified immigration attorney, you know, who practices in these areas and can provide some advice. Some of them may be able to, you know, if they've been impacted by COVID specifically or other illness, there is still the possibility of asking for a medical, reduced course load based on their medical realities. And I think there's also one for academic issues and academic problems, at least for the students in the early goings on of their education. I would urge students, if there is going to be a hybrid model, make sure to check your I-20 that you received from the school in the remarks field to make sure that these attestations that I mentioned, you know, that you will not be doing fully online course load, you know, and that the school is not doing fully online. Just make sure those representations are reflected there, because they are required to be done by the DSO. And, you know, surely they will be, but remember that the school is maybe in certain institutions will be processing thousands of these. So it's important to be aware. Greg Siskind is also, he has put a form online on his Twitter that is basically collecting students that are affected, you know, collecting their information to talk with reporters. And that just raises awareness. It's good to talk to reporters a lot of times to just kind of help raise awareness on this issue. And also just being involved in congressional advocacy, you know, and advocating with your congressman's office, I would say, is very important. You know, as I mentioned, about 100 congressional representatives have already signed on to this. So anyway, friends, this is all I have for right now. I will, you know, circulate this all around on social media. And yeah, if you have any questions, just feel free to contact me by social media or as a comment to this video that'll be posted on YouTube. And have a good weekend.